Okay, I gave you a preface, and this is a mock role play only. I wanted to be sitting up instead of more comfortable. I want to be in a sitting position, mocking a bench desk situation. Alrighty, I am not dressed in any role play costumes. This is a serious matter. I'm trying to smile and make it a nice video, but it's not really a nice video. It's just a video that needs to be there. And I am being urged by the heavenly divine to share this. I don't know why this is coming through me, but it's coming through me out into you. This is a mock role play. I am not a judge. I'm not trying to impersonate a judge. I'm not trying to commit any crimes or violations. And I'm not an attorney, and I'm not a judge. I'm not an advocate of or a member agent of the judicial system. Alrighty, I just want to let you know that I am a victim of family court, just like the people that are listening to this video. Okay, and I wanted to get it out. No fancy anything, just informational only. I'm not getting anything out of it. What I'm doing is, this is free. Alrighty, hopefully it will help you. Hopefully it will shed clarity, maybe comfort you, maybe give you some ideas on which to consult with an attorney about if you are not going into court pro se. As I said, I am not an agent of the judicial system, but I've been a victim of it in family court. And so therefore, with my age, my experience, and my wisdom, maybe I can shed something and help you, to comfort you, at least. Alrighty, on with it. Alrighty, I'm going to start with telling you that on opening day, on your court date, you're going to enter the courtroom. Okay, you sit in the gallery. Opposing parties sit in separate sides. Okay, that's fine. Keep the peace. Mind your own business. Alrighty, whether you have an attorney. If you have an attorney, it's all again, role play. Okay, if you're going in pro se, this will probably help you a lot more. I'm going in pro se, or I have been, but before, while I was in family court before, originally, I had gone through 3 attorneys, one for my divorce and the 2 others after. So, that being said, maybe this can shed some light on some matters which should have been done in the first place. In my case, should have been done the first place. Okay, this is how it should have gone down. Okay, but anyway, and I'm only speaking for myself, not for anybody else. You're going to go in there, you're going to be on the calendar. They are going to have roll call, be there on time. When you're sitting in the gallery, they're going to call your name. So-and-so, so-and-so versus so-and-so. All stand. The judge, here comes the judge. All stand. You stand up, then you sit down. You always are being instructed. That's fine. Go by the rules. Okay? The judge says, "Good morning. We have a certain amount of time for each case. I'll try to do the best I can with doing the best I can with what we have. We are allotting 15 minutes. In my court, I'm allowing 15 minutes to 30 minutes for each case. That means we're going to quarterback it. We're going to get right to the point. Alrighty. Hearsay. So-and-so versus plaintiff so-and-so, Ms. Plaintiff, Mr. Defendant so-and-so. You may approach the bench. Being sworn in, yes. Alrighty. That's established. I mean, that's pretty much routine, what you do. That's expected. Alrighty. Good morning, Ms. Plaintiff. Good morning, Mr. Defendant. Okay. Now, according to what's going on, Ms. Plaintiff, I'm going to address her first, Mr. Defendant, because she filed motions and modifications. So I am going to address that just to make sure that we have the right information that's being presented to this court. Alrighty. Ms. Plaintiff, you filed motions two of them precisely, we're going to go through it. It's pretty straightforward. Alrighty. Mr. Defendant, you did not submit any paperwork to this court for today's hearing and meeting. Alrighty, so I'm going to focus in on what was submitted to this court. That information. We're going to be pretty direct. Alrighty, do you understand? Yes, Your Honor. Okay. Ms. Plaintiff, you have filed a motion, two specifically in the motions, two ideas. I'm gonna focus in on the first one. According to this, it's number 1, which is the subject matter of the physical custody of the oldest child lives with you full time at your address. Is this correct? Yes, Your Honor. By the way, I'm Ms. Plaintiff. Yes, Your Honor, but I'm also now the judge. Okay. Alrighty, so that's established. That's established. Is that correct? Is that correct, Mr. Defendant? Yes, Your Honor. And we go back. Okay, Ms. Plaintiff, we are going back to the information about it. You have filed a motion where you are not receiving child support for that said minor child, and you're requesting child support from the opposing party, which is Mr. Defendant. Is that so? Yes, Your Honor. Alrighty, we've established it. I am going to agree, judge, and approve that because you have physical custody of the oldest child with you, you are going to be in need of support for that child. Money in accordance to finishing raising that child. Now, according to the rule at hand, your divorce and you have joint custody between both parties. That is this court's understanding. That's the information that was fed to me and presented to this court. True? Ms. Plaintiff, is that true? Yes, Your Honor. Mr. Defendant, is that true? So, yes, Your Honor. Yeah, so, that's clear. You have joint custody, 50-50. Now, according to what has also been submitted to this court in information from Ms. Plaintiff is, which can be verified, she is not plucking information out of the ethers. This is through tax records. She claims that she's making $30,000 a year, give or take. That way, she is asking this court to find in her favor of having the Mr. Defendant, who makes, according to tax records, between $89,000 and $100,000 a year, to help support that household for that oldest child. I am going to judge that as agreed right now, right here, right now, as of today. I am going to judge that in approval, and that will be submitted. That's a given. Do you understand, Mr. Defendant? Do you understand, Ms. Plaintiff? Yes, Your Honor. Okay. Now, an addendum to that is, it has also come to the notification of the fact that there is another child that was mentioned, and Mr. Defendant, I'm asking you, you have physical custody only. 50-50 joint custody, but physical custody of the said youngest child living with you full time. Yes, Your Honor, and she's paying me. Okay, yes, she is also, the court is well knowledged through the Department of Revenue that she voluntarily decided that she was going to help support the youngest child living with you full physical custody. But it remaining between the both of you joint custody. True? Okay. Now, according to the state rules, alrighty, the parent that makes more money than the other parent should not be paying at all, even though her due diligence and the court justifies what she's doing and is notified. And that's very honorable, Ms. Plaintiff, that you are willing to go above and beyond in your due diligence. I appreciate that. But, Mr. Defendant, alrighty, you by law make more money than Miss Plaintiff. So therefore, that is going to be null and void. She will not be paying you in the future. You will be paying her for 50-50 time with that said minor youngest child that lives with you full time because you make more money. That's the law. I'm not pulling that out of your ethers, out of the ethers. That's not made up. I am canceling her responsibility to pay you to help support your household, because I think you're more than enough to be able to support that household and both said minor children. Alrighty, even though they are separated in living circumstances, and if the youngest child that lives with you, Mr. Defendant, decides to emancipate themselves at a proper age and then go live with Ms. Plaintiff, that's a whole different matter. But anyway, both children are being supported by you, Mr. Defendant, because monetarily, you make more. And she's not receiving anything from you. Okay? That's a no-no. In my court. I can't speak for other courts, but in my court, that's a no-no. We're going to go be impartial. We're going to go by the law. That's set in motion. Now, that's fine that you agree that both children live separately. If you agree on that, that's 50-50 time, 50-50 time. I'm just stipulating how the children, in their best interests, are being supported monetarily. Also, any arrearage that she has paid you in the past is being returned to her. I am also going to judge that approved and I judged and agreed to as of today. So you will not only be supporting or supporting those children, but you will also return any and all arrearage that she voluntarily was willing to go above and beyond in due diligence to support that child. Now, we're going to set the record straight. This is what's going to happen in my court. Miss Plaintiff, do you agree to these terms? Yes, Your Honor. Mr. Defendant, do you agree to these terms? If you don't, well, then you can take measures in the future to actions that you wish to take. Okay, I'm not going to advocate for that because I advocate for both parents. Whether children live with you or not, you are responsible to support those children. And the parent that makes the most money supports the children. This is not alimony. This is supporting children. I'm looking at both parties. Are you in agreement with this, Ms. Plaintiff? Because you're the one who brought these motions to light. Are you in agreement, Mr. Defendant? If you have anything to say or you have anything to disapprove or any actions that you may want to take in the near future, then you have every right you would do so. That's being fair and impartial. Alrighty? But right now, I'm making decisions right now in my courtroom that are moving forward as of today. That takes care of point one. Now I'm going to quickly go to point two because time's going and I have cases. But I want to make sure that everything is being addressed in my courtroom. Point two. Ms. Plaintiff, you have brought to the court's attention that you need a solid, ironclad, set in stone, etched in stone visitation schedule. Both of you work. You're professionals. Now, what I'm going to do is I'm going to agree to an ironclad, you said in the court documents that you had one previous, but that might change. If that applies, then what you do is I'm court ordering both of you to apply by that court order set before today. by another judge. If that does not apply, then what I want you to do is, I'm court ordering both of you right now, is when we adjourn from our meeting right now, we adjourn, I'm going to have you mandated today to take extra steps before you leave this courthouse today and my courtroom. You're going to meet with a court clerk or a court advocate, and you are going to submit work schedules, and you are going to agree and submit to my office, to which I will check off the list and judge approved, agreed, and ironclad into this motion. And I will answer this motion as far as a visitation schedule between the both of you, according to what fits for your work schedule and what works for Mr. Defendant's schedule and Ms. Plaintiff's schedule, and adheres to any outside curricular activities that the children may have. 24/7, 365. I want it before day's end. I want this submitted to my office, my court, through the clerk, before you leave the courthouse today. Am I making that completely clear? Alrighty? I'm going to add another addendum to that. That's number 2. I only have 2 motions that one was stipulated. Number 2, with the visitation schedule, that Ms. Plaintiff wants one that you will both adhere to. Okay? I'm going to addendamize this before we adjourn this meeting, because I agree with all the motions that Ms. Plaintiff, and I'm being fair and impartial, everything that she has brought to the court's attention, Ms. Plaintiff has brought to the court, is very systematic, is very point blank. There's nothing that needs to be said about it. Okay, alrighty, okay. So I'm going to add another addendum to it and say it for, alrighty, okay, alright. Mr. Dependent, Mr. Defendant, what are you doing? I am criticizing you for your frivolous behavior. You're sitting, why? Why are you sitting? You will remain standing unless otherwise instructed in my courtroom, and respect this courtroom if you want respect back. I am criticizing you for your frivolous behavior during such a serious decision-making hearing, sir. And that's all I have to say about it. Are you having issues? Are you having a problem? Does the bailiff need to assist you to a standing position? Alrighty, then you will remain standing until this is adjourned. I don't tolerate that in my courtroom. I have set and stated that I agree to a visitation schedule that is going to be created before the end of the day and before you leave the courthouse. One has to be submitted. Now, if there isn't one done, Ms. Plaintiff and Mr. Defendant, and in the future, one of you do not play nice and get along for the said minor children's best interest, and you don't play nice, one of you is going to lose big and lose badly, because you're going to be held in contempt. And if I have to see you back here for a matter that shouldn't happen, one of you is going to lose big and going to lose badly. Am I making myself clear, Mr. Defendant? Am I making myself clear, Ms. Plaintiff? Yes, Your Honor. Yes, Your Honor. Fine. Then I guess, Ms. Plaintiff, I have one more question for you. Have we addressed everything that you submitted, filed, and modifications, filed motions, all of that? Have I addressed all of your concerns for today? Have I made it blatantly clear to the defendant and the plaintiff that this is going to be court ordered? You will receive copies of these court orders from me, because I'm going to draw them up myself with my clerk in detail. And you will receive copies of them in the mail. Alrighty. Now, let's see. How much time do I have? Alrighty. 20 minutes. I've gone 20 minutes. That's fine. I'm going to adjourn this case. Thank you. Thank you. And this case is adjourned. You have yourself a wonderful day. And believe me, don't leave the courthouse until you submit work schedules and you set a schedule. Even if it's tentative. Ask your employees to work with you. You have court orders. Employers will work with court orders from me. They by law have to work with you on a schedule. And also garnishment. You have yourself a wonderful day. It's been 20 minutes. I am allowed 15 minutes to 30 minutes per case. Now I have to go on. I'm going to take a short break. This case is adjourned. Unless drastic changes have to be made as the children grow older and things have to be adjusted. But for issues that were brought up today, between monies and visitation schedule, that's set in stone. Okay? Order in the court. Okay? Thank you. I appreciate your time. Each case gets 15 minutes to 30 minutes. I am going to set, bailiff, I am going to, clerk, I'm going to take a short break. I'm going to go in the back. I'm going to, between each case, I take a short break because I need to be familiar with the paperwork in hand and the case to make sure that the next case ends up getting clarity. And motions and modifications get addressed. Thank you. That's the way it should have gone. That's the way it should be. Thank you. All right. Okay. Makes it easier for the judge. It makes it easier for them to make decisions. It's less stress, and it makes things crystal clear between both opposing parties and opposition. Okay. Blessings to you. Thank you. Thank you for your time.